Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to talk to you about what are affirmative defenses. And you'll find this typically in Rule 8 of your state rules of civil procedure. And the federal rules are kind of the guideline that most states are based on. So it's Federal Rule of Civil Procedure 8. And if you look in there, you'll see examples of affirmative defenses. So what in the world are these things? Well, these are defenses where I'm the defendant and I say to the plaintiff, the person that sued me, you may be right. Let's assume you're right. You still lose because of this affirmative defense. So sort of the classic example is statute of limitations. So let's say that I'm driving a truck and I run over somebody and I'm drunk and I'm speeding, all this terrible stuff. And they sue me and they say, oh, John was driving a truck and he was drunk and he was reckless and malicious and just terrible. And I say, yeah, you're absolutely right. I did all that. And I know I, destroyed your body and just, ruined your life. But you lose because of statute of limitations. You waited one day too late to sue me. Or there can be a statute of limitation about we've already settled this, or maybe in a prior case we've litigated this and I won, so you don't get a chance to sort of get a second bite at the apple. And if you look in Rule 8, you'll see a whole list of these affirmative defenses. And just remember, the point is that the defendant is not challenging whether the plaintiff is correct. The defendant's just saying to the plaintiff, the person that sued, hey, let's assume you're right. You still lose because you waited too long, or we previously settled this, or we previously litigated this, or whatever the case may be. And so if you're being sued, maybe in a debt collection case, maybe in a foreclosure case, if you're in a state that does what's called a judicial foreclosure, you want to make sure you look at those affirmative defenses and say, which ones apply? Because the general rule is, if you do not plead or put that in your answer, your response, then you waive them. So you have to bring them up or you lose them. So anything that could apply, you want to bring that up. And that tells the plaintiff and the court, hey, look, I'm saying this affirmative defense is something that I'm relying on here. Now, this is beyond the scope of this video, but it gets a little complicated. And what are the standards? You have to put facts with those. But just understand, affirmative defense says, yes, I may be guilty, but I win, you lose, because I have this defense that just totally kills your case, okay? And so if you're on the plaintiff side, all right, so in my world, I'm always on the plaintiff side suing companies, except if I'm defending somebody sued by a debt collector, then I'm on the defense side. But on the plaintiff side, we have to think about this and say, what are the affirmative defenses they may raise? And then we look at the ones they raise and say, are these legitimately raised? Or can we knock out a bunch of these, maybe all of them, and then eventually we want to get rid of all of them, or turn them around on the defendant. So I'll give you an example. In Alabama, I think I did a video on this. It's called contributory negligence. So Alabama, maybe Virginia, Maryland, I don't know, maybe DC. We're the only places that have contributory negligence, which that's where, let's say I'm suing somebody for running through a red light and crashing into my car. So I sue them for negligence. And they say, you know what? I did it, but John, you were 1% at fault. Well, 1% at fault, at least in Alabama where I practice, that means I lose. I completely lose. So see, that's an affirmative defense. It says, yeah, I was negligent, but the plaintiff, the one suing me, the injured person, was 1% at fault, so they don't get anything. Now, most states use something called comparative negligence, but in a contributory negligence state, that's an affirmative defense. It just wipes out the whole case, okay? So if I know the other side is pleading that, then I may use that in a jury trial and say, you know what? These guys, first of all, they haven't apologized for what they did. They haven't taken responsibility. And you know what? They're blaming my client, saying my client's at fault. As my client's sitting there at the red light, boom, they smash into the back on. They go, you know what? You're at fault. How am I at fault? well, you should have seen us coming and gotten out of the way. You should have known that I was driving 80 miles an hour and I was going to crash into your car, so it's partially your fault. See how stupid that is? So we turn this around on them to really make them regret ever pleading that. So anyway, I'm going off a little bit of a tangent there, but just remember, affirmative defenses say, yes, plaintiff, you're right, but you still lose because of my affirmative defense. And look at Rule 8 of your Rules of Civil Procedure, and you'll see all sorts of examples of those affirmative defenses. Okay, guys, thanks for watching.